All rise. All persons having business before the Honorable Associate Judges, now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save the United States and its honorable court. This honorable court is now in session. Please be seated and come in.
Good morning, everybody, and welcome to the District of Columbia Court of Appeals. We have 3 cases on this morning's regular calendar, but the first 2 are going to be heard with this panel, and then we will take a very short break to reconstitute the panel. And for the 3rd case, Judge Howard will be replacing me. So when things start going crazy, that's what's happening. The first case is number 22 FM 693, ANDREA CALABRESE versus Kelly HOYLE.
Good morning, Your Honors. May it please the court. My name is Marshall Yap on behalf of the appellant, ANDREA CALABRESE. We are appealing the trial court's award of physical custody and legal custody, requesting that this court reverse the trial court's order, issue a mandate awarding the parties joint physical custody and joint legal custody, or in the alternative, remand the case for further proceedings. DC Code 16-914A2 provides that there shall be a rebuttable presumption that joint custody is in the best interests of the child, except in circumstances where there's been an intrafamily offense. The trial court in this matter manifestly abused its discretion in finding that Mr. Calabrese committed an intrafamily offense when he engaged in actions that, from our standpoint, are perfectly legal in the District of Columbia.
Did you, I know you raised several challenges to the stalking determination. One question I had was as to the constitutional attack on it. A, did you raise that in the trial court? And B, how do you get around the Beecham case? Isn't that addressing the exact same thing?
It was not raised in the trial court. And I realize that the Beecham case does address the notice issue. I guess I'm looking at the Beecham case from a little bit different standpoint than I probably described it in my brief, which is that the Beecham case says that there won't be an intrafamily offense, there can't be stalking if there is no way that the defendant could have known that his conduct was prohibited. That's a quote from the case, not a direct quote, of course. But so yes, I agree that that vagueness perhaps has already been addressed by the court.
Okay, so then you're left with sort of a sufficiency attack on the stalking determination.
I would agree with that, Your Honor.
Okay, so what is your best argument as to why this wasn't stalking?
So my best argument is that the statute specifically allows a party to record in the District of Columbia. You're allowed to make recordings. That's allowed under the wiretapping statute because this is a one-party consent jurisdiction.
Just to make sure I understand, do you think there's ever a situation where someone might be recording another person and the person who's doing the recording is consenting to it or actually doing it, where that isn't relevant, to course of conduct in a stalking matter?
I think that it's always permissible because the statute says it is permissible.
So just because we're a one-party recording jurisdiction, you can't harass somebody through the course of recording them if you were simultaneously yelling in their face or blocking their way or doing other conduct that might make a reasonable person fear for their safety?
Well, it's true that the yelling in somebody's face might be considered stalking, I suppose. But the recording itself, that's my argument, is that it's not stalking because it's specifically permitted by the statute. And so the person who is doing
that it's not prohibited by the wiretap statutes, but it doesn't mean that it's not stalking.
You're correct that it's not prohibited. I think that you don't have notice of whether your conduct is prohibited or not, because the statute does allow it. It's not prohibited. So let's say if you're an attorney and you're advising somebody and your client does many recordings, how does that client ever know that this is going to be stalking? If the statute
that sounds like you're getting back to the constitutional argument, but I thought we were going with a straight sufficiency argument. So say I decide that I'm going to follow Judge Beckwith around with like one of those big movie microphone things, they're sort of fluffy and and so I just walk behind her 3 feet with this thing hanging over her head for 8 hours a day, and I follow her everywhere. So, she goes to the bathroom and I wait outside the bathroom and I'm right there and I just follow her and I'm just recording every hello, every thank you, every conversation she has. And you're saying because because one party recording is permitted, that's not stalking?
I think the following around could be considered stalking under the right circumstances. Arguably, the circumstances in this case, there was some following around going on according to, in the trial court's findings, but the parties were residing in the same home. So I would arguably.
No, I'm not talking about these facts. I'm just asking, you seem to be making the argument that because one party recording is permitted, that any recording of a person cannot constitute stalking. And that seems like an
I'm making that argument.
overbroad argument.
I would argue that the statute is overly broad because it.
But I thought we were talking about sufficiency. So now you're flipping back to constitutionality.
I suppose I am. I think that if you don't know if the statute allows you to do one thing, I don't understand.
Let's assume that the statute is constitutional. I'll go back to Judge Beckwith's question. What's your best argument for this evidence being insufficient?
That because if I understand your question correctly, because you are legally permitted to record people in the District of Columbia, you can't engage in stalking by recording people.
Have you, is there any case law one way or the other involving people who are married or living in the same house going through a divorce, where stalking is either charged or found like this in a statute that for which it is relevant that it happened, or there's a finding by a preponderance? Is there any case law about, stalking occurring in the house?
I did not see any case law that addresses that. And I guess from my standpoint, what the trial court found here would sort of be an unreasonable extension of the stalking statute. I mean, these, as your honors can imagine, these sorts of contentious situations happen in divorce cases in marital homes frequently. And I think that, it's a slippery slope if we start charging people or finding that people are guilty of stalking for conduct that is unfortunate, but very frequent.
I guess that this is maybe the bigger question, which is the trial court wrote a very long and thorough order here. And even though it's true, she did find that an interfamily offense occurred and that it was stalking. She also said, even if that presumption, the presumption that is triggered when you find an interfamily offense, even if I didn't find that, I still find that the evidence overcomes the other presumption of joint custody. Doesn't that make the whole stalking issue irrelevant, harmless, however you want to put it?
It would, Your Honor, if there weren't all of this other compelling evidence that supports a joint custody arrangement. And I went through a lot of that.
Before you get through that evidence, it seems to me that the court here tried joint custody and that it really wasn't working out. And so the court had to modify that to the custody that looks pretty similar, if not identical, to what ended up being the final order. And so I'm wondering, why isn't that sort of the best evidence that joint custody is not appropriate?
Well, I think part of the issue here is that, as the expert Dr. Farber found, the trial court shouldn't focus so much on the relationship between the parties. I mean, I think a lot of what's in the trial court's order is based on interactions between the parties, and they're contentious and they're unfortunate. But I think Dr. Farber was still thinking that, set that all aside, this gentleman still has the ability to be a good father, and these parties should both co-parent.
But I think what Judge Ali Khan was alluding to was findings that when custody was shared more equally, there were adverse effects on the child, right? That it seemed like the father was telling the child, oh, if you act better, if you do things differently, I will be able to see you more, right? The father was putting the onus of visitation on the child and causing the child emotional harm. And then the child was acting out towards the mother as a result. So it was definitely, this wasn't just a dynamic in between the parents. The father was, bringing the child into this sort of triangulation and using the child. I thought that was the findings that supported the court's determination that visitation needed to be reduced and to come to a schedule that much more resembles what the court ultimately settled on in the permanent custody order.
Those were the trial court's findings. Mr. Calabrese would take issue with the idea that there's been emotional harm. Again, this was a very contentious time. It's a child custody dispute. Everyone involved is upset and trying to move on with their lives. I don't think the court's findings justify the very, very limited custody schedule that was entered in this case. It's every Wednesday night and every other Saturday overnight. And that's a very limited custody schedule that I don't think is warranted by the court's findings.
The court also said that you could seek to modify if your client were to seek mental health treatment and address some of the things that the court found concerning. So doesn't that seem like your client could sort of rectify what you see as a very limited custody schedule?
I agree with that. If he were to participate in therapy and follow the court's recommendations, then at some point under the law, he would have the right to seek modification if there's been a substantial material change in circumstances and if the court finds that it's in the child's best interest. So, Your Honors, I would like to just go through some of the evidence that we think weighed in favor of joint custody.
And when you're doing that, keep in mind your time is running down and we're pretty familiar with the facts, but I'm interested in your response to this, which is a lot of your brief seems to focus on the facts that you think are good for your client. And the judge made a lot of findings. So it's kind of unclear at some points whether you're saying that finding was clearly erroneous or whether the things you're referring to, the facts you're referring to are just things that you think are undisputed or what. But when you're talking to us about this, I'm curious about those things.
Sure, I can address Your Honor's question. It's true that a lot of the facts are undisputed because a lot of the facts were taken from recordings made by my client. I guess our argument is that, again, I'll go back to what I said earlier, which is that this is a very contentious time between the parties. Dr. Farber noted that the court should not focus on the interactions between the parties and should focus instead on what is in the best interest of the child. And we would urge the court to take that into consideration. And I'll actually just go ahead and reserve the rest of my time for rebuttal if that's okay.
Okay, thank you, Mr. Yap. Did I pronounce that right? Yap?
You pronounced it correctly.
Okay.
Thank you. One of the rare people who does so.
Oh.
Should I go ahead?
Yes.
Thank you. May it please the court. I'm Hope Stafford here on behalf of appellee Kelly Hoyle. As the court has already referenced in some of the questioning of appellant's counsel, this wasn't actually extraordinarily well-supported custody ruling, and there's no legal basis to overturn it here. There was basically the proverbial mountain of evidence before the court regarding the father's very, very problematic parenting and co-parenting behavior during the course of the marriage, during the separation, and after the separation, after having been told over and over again.
I think we need to reach the stalking question, or can we affirm on the court's alternative holding?
I do not think this court needs to reach the stalking ruling. I think the stalking ruling could be, completely removed and lifted out of this order, and the custody determination would still be very well supported. Some of the factors under which the court assess the stalking claim would absolutely be relevant facts for custody, whether it ultimately resulted in a determination that the intrafamily offense occurred. Those are still relevant for parenting and co-parenting. But the ultimate finding that the intrafamily offense occurred, it really had no effect on the ruling, because with respect to legal custody, the court explicitly said whether or not the presumption had been shifted or overcome, joint legal custody would not be appropriate here. And with respect to physical custody, the court said that the court awarded joint custody. So regardless of the presumption shifting that occurred as a result of the finding of the intrafamily offense, the result would be the same. And the court was kind enough to tell us that. So we don't really even have to wonder.
Although you do get the impression that the judge cared about the fact that she believed that the dad committed a crime, a serious crime. And I wonder if I could just ask you a couple of questions about that finding. And it also, I think, affects our view of the facts, because it's either we have to decide whether we're overcoming a presumption or starting the opposite way. Did that make any sense? But can you tell me what is your understanding that the two or more occasions that make up the course of conduct from the stalking statute actually are?
Yes, Your Honor, I believe that the conduct that gave rise to the stalking finding was the following monitoring and surveilling of Dr. Hoyle for hours and hours and hours, for days and days and days on end, while talking. And yes, there was berating and belittling, and I'm mindful of the Michelle ruling. And I think that this court can read this ruling without taking into account the content of what the father was saying and still reach the stalking conclusion, because following someone, and so this conduct, according to the record, went from at least November 11th, 2020 until December 16th, 2020. And what the mother's testimony and all of the evidence showed is that every day throughout the house, throughout the day, he was following her, he was recording her, and it wasn't the mere fact of the recording, it was the manner of the recording. It was the, holding up the phone and showing he's recording, or holding up the phone and pretending to record while not recording.
Do you think that we don't have to specify dates? I mean, we have recordings from different dates. Do you think that it's just enough to sort of paint with a broad brush and say, there are all sorts of recordings, this happened a lot? Pick any two will do? Or do we need to drill down and be more specific and say, at least on this date and this date, he was engaged in stalking. He knew or should have known that his conduct would have caused a reasonable person fear.
I think that I think the court addressed that in the findings. There were dates listed of various of the various conduct that the court had found was the stalking behavior. And I know that the court referenced, the fact that if something continues for 24 hours, each 24 hours constitutes an individual finding or an instance. But I don't think that it's, if it's the fact that the court didn't say it happened from this date range, and I'm going to put a bulleted list of each instance of conduct, I don't think that's fatal to the finding when the reader can understand that it was these actions that this person took over this course of time in this manner that violated the statute over and over and over again.
I guess my question, is in addition to the course of conduct, and which are we exactly talking about, is the part about a reasonable knowing, or should have known that a reasonable person, this behavior would cause a reasonable person to feel alarmed, or whatever the language is, frightened or suffer emotional distress. So I think our case law has been clear that that's a high standard. Like, it's not just you're annoyed or you're really upset. People get upset a lot. And doesn't mean someone's stalking them necessarily. So I wonder, like, one of the passages that's it's excerpted a lot in your briefing and in the trial court's order is this reference to saying the dad was very critical. This is the mom's testimony, Ms. Hoyle's testimony. He was very critical. He was stalking me around the house. He was recording, constantly recording me. He was talking for hours on end and almost like holding me hostage, talking to me. At one point, he was talking for almost 6 hours straight. I had to just run out of the house. I just couldn't take it anymore. And I've listened to some of the recordings, and you definitely get the feeling that Mr. Calabrese has he's a talker and he talks nonstop, and I can imagine it would be annoying when you're going through a divorce with him. That seems like what she's talking about. Like not so much I'm an actual hostage here. What is your response to that?
Yes, we definitely in family law have to draw a distinction between being annoying and being abusive. And that is an important line to draw all the time. This case was in the entirety of the evidence very far past the level of annoying for two reasons. One is when all of the recordings are reviewed, and of course there was only enough time to put some of them into evidence and not all of them. And then also on top of that, that was 55 hours, but the period of time he was doing that those were just the ones that were recorded. Dr. Hoyle talked about conduct that happened that wasn't always recorded. So the volume of it really did rise past the annoying level to the torturous level, both I think objectively and subjectively. And if the court had a chance to watch, there was one video that was admitted when Dr. Hoyle did leave with the child, and she's visibly terrified, as is the child. Now the father in that video he's actually not screaming, he's not being violent, but this was the same tone that he took the entire time, and the cumulative effect of that apparently, and it was very, very clear, was for her to be terrified. And I do think she used some other language throughout the course of the testimony, that she was terrified, at least the court found, and there's a transcript reference here. The defendant caused plaintiff to feel like she was walking on eggshells. He was intimidating and she was terrified. And that's at the November 15th transcript.
Yeah, it actually says it was like walking on eggshells. It was really just, he was very intimidating. It was terrifying.
It was terrifying. Yes.
I guess that slight difference between I was terrified, but probably the same thing.
That is fair, Your Honor. So in terms of, I think there was ample evidence here for the court to conclude that this rose past, besides the plaintiff's own testimony about the impact on her, to be followed around. And she also talked about she wasn't permitted to be alone with the child. She wasn't permitted to leave the house with the child. He would physically stop her from leaving with the child. The video shows him trying to stop her physically from leaving, in multiple ways, going into the Uber, taking out the car seat, taking the car key out of her car. There's multiple ways that he's trying to stop her.
Although, is that part of the course of conduct that the judge was considering? I mean, not clearly considering, but, was that one of the occasions specifically?
Well,
was it all recording? It seemed to be recording?
The course of conduct did include that last act. And I actually think the court might, I don't remember for sure, but I think the court might have referenced that it went until the 16th. But it certainly illustrated visually what we were hearing on the audio, which was just the level of pursuit. You go here, I go here, you go here, I go here. And that is the conduct that from November 11th till December 16th, she was enduring in her own house, where, it would be very different if, just every time they crossed paths, he was being rude, or even if he was belittling or berating or anything like that. That's a very different fact pattern. That is not what happened. It was the pursuit of her, the constant pursuit, as she talked about it. So I really, in this particular appeal, was, as the court has so much discretion, in a custody case. And as there was so much evidence supporting the limited custody that father was awarded, there's clearly no manifest abuse of discretion. And because
what does that mean? I know you say in your brief that that's, one of the, I forget what your term is, but and I forget whether we want to say really stringent or really deferential. It's one of the most deferential standards, but is it any different from abuse of discretion?
that is a fair question, Your Honor. It sounds more.
Yeah.
It sounds like more. It's another word.
Yeah.
I wouldn't say that even if it was just reviewed under an abuse of discretion standard, it would be error. So I, to be candid, didn't research that further step because I don't think it's even necessary. It's not an abuse of discretion. It's not anything wrong. It's not, and it wouldn't meet any standard. There was so much evidence. And to the court's point about the stalking, if those sentences are stricken, I didn't get to answer the court's question about the trial court having seemed troubled about the fact that father had committed a crime. I do not read the ruling that way. What I understood the trial court to be troubled by was the commission of the elements that do in the District of Columbia add up to stalking. And these intrafamily offenses, they are relevant. The reason why they shift the presumption is because they are like a proxy for problems that will impact on parenting and co-parenting. And so I think what the court was really focused on is, here's a list of behaviors that we've already looked at. And we've decided that this has some real negative impact on parenting and co-parenting if a person does them. And he has done them. I actually
Can I
don't
ask you a
find.
quick question about that, just to
Yes.
clarify the factual record? So I agree that the sort of prior visiting history showed that there was a real trouble with co-parenting, and that I think probably impacted some of the trial court's consideration of the factors. But the father also at some point requested like a parenting coordinator or someone to kind of assist with these transitions. And did that ever happen? And what was the result of that?
So the parenting coordinator, what a parenting coordinator is, they don't go to the transitions. A parenting coordinator, it's not quite like a mediator, but it's more like a mediator than a supervisor, which would be someone that would monitor the transition. So a parenting coordinator is a person who can be helpful in implementing a joint custody arrangement because they facilitate communication. And so, but the parenting coordinator only works if a person listens to input. So, a parenting coordinator will say, you know what, from now on, take out all these sentences where you're criticizing mom and just ask the factual question, what time is swim class, right? And they'll give that feedback. And then the person though, then has to take that feedback and implement it, or it's pointless. They can act as like a filter, but that's not really sustainable. These people charge by the hour and they can't, that's sort of like co-parenting with a third person.
Is it Jordan versus Jordan? That's the main,
Yes.
the main case on that. Wasn't that a case where the two parties really couldn't speak to each other at all either? Or is there evidence in that case of what you just said that they could at least do enough to have this facilitator person be useful?
Yes, in that case, as I recall, in that case, what happened is that the parent coordinator, there was a couple of things that were different. I believe in that case, I did not read that before just today, read it before. There was a parent coordinator that was during the litigation, right? It wasn't, I'm gonna point a parent coordinator and send you off into the sunset and, I hope it works. So there was some data, just as Your Honor was saying before about the data the court had collected about what's gonna work and what's not gonna work with custody. There was some data to be gathered about how the parent coordination process was working or not working in that case. And here there was none. Had the father said during the pendency of the litigation, like, let's try a parent coordinator, we can argue about whether that would have had an impact or not, but at least there would have been evidence. There was no evidence here. And so I think the Jordan case was distinct on that factors, but every case is going to be very fact specific. And that was, predominantly that was an alienation case. And I actually do not recall the specific There had been like some isolated incidents of violence between the parents, and I think everybody fought about whether it was situational or not and that sort of thing. But at the end of the day, what I don't remember is what their communication dynamic was and the problems or not, and whether that some of them, of course, a parent coordinator is for divorcing people, right? So there's always going to be a problem with the communication dynamic for that to be an intervention that happens, but it doesn't work with every dynamic. That's a problem. So I can't remember if I was midstream answering somebody's question. I see
Sorry.
that I'm out of time.
You
So
were.
if there's nothing further from the court, I think that this, is a well-supported opinion and need not be disturbed on any grounds.
Thank you
Thank
very
you.
much. Mr. Yap, we'll give you 3 minutes.
Thank you, Your Honor. Just a few points here. I didn't mention this earlier because I know that the court has looked at the facts of the case and understands the facts, but I just wanted to emphasize the fact that Dr. Hoyle was recording before Mr. Calabrese ever started recording. She was also keeping what she referred to as a journal, but when you look at the journal, it's actually just documenting everything that Mr. Calabrese does. So we characterize it as an evidence log, and I think we did so appropriately in our brief. She even provides notations where she was recording Mr. Calabrese. So she started off really surveilling him.
Did you argue that that constituted an intrafamily offense below?
That was not argued below, Your Honors. But arguably, if that, I think correctly, it wasn't argued below, and this shouldn't have been argued below either, that his recordings of her were an intrafamily offense. So I think that's in line with everything I've said. The other thing is in Jordan v. Jordan, I did just glance at the case. I didn't read it thoroughly here while you were talking, but a couple of buzz phrases popped out at me. And one was that between this couple, it was fraught. This relationship was fraught with conflict. It was a high conflict situation, and there were allegations of several violent episodes. And in this case, Dr. Farber recommended joint legal custody. He recommended that a parenting coordinator be appointed. And we think that that would have been an appropriate conclusion for the trial court to reach as well. The incident, I'll just briefly address the incident where Dr. Hoyle is taking the child out of the house, and there's a video of this. Again, I sound like a broken record here, but it's a high conflict situation. Each party is concerned about what's going to happen to the child, who's going to have the child. Is one party going to be keeping the child from the other person? And of course, this is going to be a high stress situation. I think hindsight is 20/20.
But Mr. Yeah, these are almost always high stress situations. And that's why we have a family court judge that sort of sees the full panoply of these cases. And here it seems like she found that nearly every factor weighed against your client's custody. And so I suppose why is that an abuse of discretion?
Because if you look at all the evidence that weighs in favor of Mr. Calabrese having evidence, that's where I think the abuse of discretion is. I think that there are many facts. He's a loving father. He has a great relationship with his daughter. There are many facts in the record that support those findings, and I think that that weighs in favor of joint custody. In addition to the fact that Dr. Farber found that it would have been appropriate to have a schedule where Mr. Calabrese had more time than the trial court awarded.
It did seem like the trial court acknowledged a lot of the good traits about your client and his relationship with his daughter and his love for his daughter. But again, as Judge Ali Khan said, that's what trial judges do is look at factors. A lot of them are going to be in conflict with each other and balance. And so, isn't that what she did here? The trial judge, I think it was a she. Yes, Judge Wingo.
Well, I guess I'm also going, from our standpoint, the whole issue with the stalking sort of affected everything here. I think that the court wasn't starting from with an equal playing field because of that presumption. I think had the court done that, things might have been differently. I don't know that in the court's opinion, it expressly states with regard to physical custody that that had she not found stalking, she would have found all these things anyway. I think that she might have found that with regard to joint legal custody, but I don't think she expressly stated that with regard to joint physical custody. And so, I think that had stalking finding not been made, things might have come out differently.
Didn't she find joint custody though? Joint physical custody?
Did she find joint physical custody?
Yeah.
If that was the language she used, that's not how it plays out in reality. I mean, it's a very limited schedule. Again, it's every Wednesday overnight and every other Saturday overnight. So, those are semantics that we all understand are sort of, are vague. Sometimes saying joint physical custody makes people feel better about the situation, but the fact is that it's a very limited schedule, and in reality, it's not really joint physical custody.
I see.
Okay,
Thank you very much.
Thanks.
Thank you for your briefing and your arguments today, and the case will be submitted.
Thank you.
Second case on this morning's calendar is number 22 CV 749. Donna M. GERACI versus Ian Hamilton.
Good morning, and may it please the court. My name is Matthew Lee, and I represent the appellants in this case, Donna GERACI and her practice, Creative Ways Therapy, Inc. As an initial matter, Your Honors, may I request to reserve 2 minutes for rebuttal,
Sure.
please? The dispositive issue in this appeal is the nature and scope of the immunity afforded to mandatory reporters of suspected child abuse under DC Code Section 41321.04. Specifically, in this case, what good faith means as used in that statute, when good faith is to be assessed, to what claims it applies, and how the statutory presumption of good faith impacts the burden on the parties, particularly in a summary judgment setting. Now, as this is an interlocutory appeal, there's always an initial issue of whether or not this court has jurisdiction under the collateral order doctrine in the 3 prongs. In short, it does. This court's decisions dating back to Finkelstein back in 2000, all the way up through the Nash Flagler case, instructed this case, the collateral order doctrine is satisfied when the trial court denies a defendant immunity.
Do you think this is an immunity from liability or an immunity from suit?
I think that's respectfully, I don't think that's a distinction that's not recognized in the law, Your Honor. That is what my opponents have said. The issue.
Well, if I think it's a distinction that's recognized in the law,
Yes.
which side of the line would you put it on?
I would say this is immunity from suit. The distinction that comes up oftentimes, particularly in Mitchell v. Forsyth, in Johnson v. Jones in front of the Supreme Court of the United States, is whether or not the immunity attaches to prevent a defendant from answering or going to trial to begin with, versus whether or not the defense is as to the merits of the subsequent claims themselves. And that dichotomy is borne out in the Johnson case, which the appellees believe supports their case. It does not. And John.
But can we drill down into the language of the statute that confers immunity?
Yes, ma'am.
Right. So the first sentence of the statute says any person, and I'm going to insert ellipses, any person participating in good faith in the making of a report pursuant to this subchapter shall have immunity from liability that might otherwise be incurred or imposed with respect to the making of the report. So the first sentence talks about immunity from liability. And that seems to be the one sentence that people have talked about in the brief, but then there's another sentence to the statute that I don't know that anybody talked about in the briefing. And it says, any such participation shall have the same immunity with respect to participation in any judicial proceeding involving the report. And I'm trying to figure out what that second sentence means, because it seems to add to the first sentence saying there's immunity from liability. And then the second sentence saying any such participation shall have the same immunity with respect to participation in any judicial proceeding involving the report.
Your Honor, I do think it does add to the immunity. I think the first sentence is extremely broad as written. It's liability, comma. Excuse me.
But liability just, I mean, that would just mean like, look, at the end of the day, you can't be held liable, but it doesn't mean that you can't be hailed into court, right? And so if it were just immunity from liability, I think that would support you, because you could say, look, we can still take her to court and we can show that she wasn't acting in good faith, and there are disputed issues of fact on that, right? But it's the second sentence that says, that you're immune from participation in any judicial proceeding. That seems to suggest you can't take her to court. Am I?
That to me, Your Honor, is, I think, I agree.
Like I said, I didn't see any discussion of this in the briefing, so I'm just not sure what either side thinks this sentence means, or how it's been interpreted in other jurisdictions, or how it's been interpreted in this jurisdiction. I take it there's no case law interpreting this statute in this case. All we have is an unpublished ruling from a trial court, which is not precedential over this court.
That's correct, Your Honor, and that's part of the problem, I think, that faced the trial court and the parties in this case, is that there hasn't been any.
Right, but when you don't have precedent, you usually go to the text.
Yes, ma'am.
So
And
what does this second sentence mean?
the second sentence, well, I think the second sentence means, in my opinion, that it extends to the reporter's participation in judicial proceedings, in any judicial proceeding involving the report. I think that that's the way the statute is worded, and I think it's very broad in application. I do think that the immunity doesn't mean you can't be sued. Immunity has to be asserted as an affirmative defense.
But this, I mean, sorry if I'm just sounding repetitive here, but if you're immune with respect to participation in a judicial proceeding, that does sound like you can't even be sued. That does sound like it's a free pass. The complaint gets dismissed.
Judge Easterly, if the court wants to take, I think that'd be a very broad.
I mean, I don't know. I'm asking, like, what is your interpretation of that language if it doesn't mean that you can't be sued?
Well, if that's the court's interpretation, if that's going to be the court's interpretation, I'm happy with that. As far as my clients are, I had read it more to do with the.
You would be happy with that interpretation? I mean, that would mean that you would lose, right?
My clients are the ones asserting immunity. If you're saying that my clients are that the statute prevents anybody from suing them from making the report, then
My mistake.
And I apologize if I confused.
No, my mistake. So, okay. So whether it's immunity from liability or immunity from suit, you're saying you're immune.
I don't think there is a distinction in the law, and I think there's the decisions both from this court and from the United States Supreme Court, from which this court derives its collateral order doctrine precedent, do make that clear.
So do you think, do we still have to jump through the hoops of the collateral order doctrine and all of the prongs? Or you're just like, this is an immunity question, and there are cases saying this is, if this qualifies, we can appeal this.
Yes, Your Honor. Judge Easterly and you, Judge Beckwith, were both on the panel for the Competitive Enterprise Institute. I believe, Judge Beckwith, you were on the Nash Flagler panel. The decisions, there's four main decisions, starting with Finkelstein. And what ends up happening is these things are intertwined almost always, because people take the interlocutory appeal because they feel that they shouldn't be forced to go to trial. And in reviewing the interlocutory appeal, they assess whether or not immunity is one of those situations where it satisfies all three prongs of the collateral order doctrine. Each time, this court has said yes. there is not, to my knowledge, a published decision out of this court denying jurisdiction.
But is it a potentially a case by case thing? Like
Right,
in
I
this
think-
case, if bad faith is the question, isn't that kind of tied in with issues that might arise in the negligence matter? So there's some overlap between the issues, or is that not how you look at it?
I think that the overlap issue comes in, I think maybe in the second prong when you're talking.
That's what I'm talking about. Yeah, yeah.
When you're talking about whether or not it goes to it's separable from the
Yes,
merits.
right.
Obviously, there's always, as the court's decisions indicate, there's always some overlap. In particular in these types of situations, because the immunity is central to the collateral order doctrine, whether or not this court has jurisdiction. And then once you determine you do have jurisdiction, then you determine whether immunity was properly denied or not.
Maybe there's how I, oh, go ahead.
Can I ask you a question about that? So, but let's say we have collateral order jurisdiction and we go to the merits. This suit covers conduct much broader than just the report, which the statute seems to give immunity for. So how much of the suit do you think that your clients would be immune from?
As we wrote in our briefs, Your Honor, I think that all of Mr. Hamilton, the father's claims arise out of either the report or my client's involvement in the custody proceeding in front of Judge Becker below, or in the fair hearing. And not to, I don't need to get into the facts, but most of the facts in this case are undisputed. There is no dispute that a 3-year-old girl told my client that she performed oral sex on her father on September 8th, 2017. There is no dispute that my client made a report the next day to the investigating police officer. There is no dispute that that investigating officer himself, a mandatory reporter, made a report his own. There's no dispute that CFSA substantiated the disclosure. There's no dispute after a 5-day evidentiary hearing, a hearing examiner found by a preponderance of the evidence that it was properly substantiated. So I do believe as far as the father's claims go, Your Honor, that they are all encompassed by it. We lay that out in our briefs, and it's in their amended complaint.
Well, I'm looking at the amended complaint, and in particular, I guess it's page 20. Let's see, 25, I guess it is 26, where they're talking about negligence in the play therapy. That seems to me to be distinct from any participation in any judicial proceeding.
Your Honor, it would be if it was applicable to the father. The father was not a patient of my client's. The father is still asserting that we owed him a legal duty, negligence duty, even though he was not a patient. The play therapy was for the 3-year-old child. And so
do you think that immunity then wouldn't cover the claims that he's bringing on her behalf?
On her behalf, Your Honor, as we indicated, I didn't want to overreach in this case. There perhaps are some alleged breaches of the standard of care that do not have to do with respect to the daughter, that do not have to do perhaps with the report or her involvement in the legal proceedings. Obviously, I think it would be disingenuous to argue that that the immunity attaches to medical malpractice in the actual treatment of it. But with respect to the father, Your Honor, to answer your question, all of his claims are to do with the report or the ensuing judicial proceedings.
So your position is the denial of immunity is purely a question of law?
Yes, Your Honor, and I think that Wamata v. Nash v. Flagler, 272 A3rd 1171, page 1180. The denial of immunity is a legal question to be reviewed by de novo by this court.
I think that's generally right, but typically immunity doesn't turn on good faith. And so here, isn't there sort of a baked in factual finding about whether or not someone was acting in good faith before you can decide whether immunity attaches?
Perhaps, Your Honor, but remember, this statute has a presumption of good faith. Most other state statutes do not. Maryland does not, Virginia does not. And we cited 2 decisions where the courts there inferred a presumption and ruled in favor of the mandatory reporters on summary judgment and as to all claims, meaning intentional infliction of emotional distress, not just negligence. And here you have the rebuttable presumption expressly put forth. And unfortunately, the trial court did not address that issue. What is necessary to rebut the presumption under the statute that she did act in good faith in making the report? There is no discussion in that.
If this is an immunity from suit, I know you don't think that's a distinction with a difference, but I do. Would he have to allege sufficient facts rebutting the good faith presumption in his complaint, or could he do it later in the suit, perhaps opposing summary judgment?
I think we could have challenged it based upon the allegations in the complaint. We decided to be a little bit safer and do some discovery. Unfortunately, COVID hit, and this has taken on a life of its own for several years. So we decided to do some discovery because there is absolutely no relationship between the father and our clients before the report. There's no animosity. There's no bad grudges. There's no bad faith. The distinction between and I would go back to the Johnson v. Jones case, and I go back to this court's precedents. It's to try to say that they're saying it's immunity from liability, immunity from trial. There is no, it's immunity. If you have immunity, then you should not be forced to go to trial. I
think that would be right if you had filed a motion to dismiss, and I guess I assume chose to raise immunity later in the stage after discovery. And I guess I'm just wondering, at that point, have you kind of conceded almost that any sort of facts developed through discovery would come in when we're looking at the good faith analysis? Or are you saying that we can only look at the allegations in the complaint?
No, Your Honor, it's a Rule 56. So obviously the trial court in this court may look at facts, but they have to be evidentiary facts. They just can't be bald allegations. But to your point, Your Honor, we didn't rest on the presumption of good faith. We could have just filed a motion for summary judgment and said the statute says presume good faith, and they don't have any facts in evidence to rebut it. But we went further. We took the facts from the underlying case, undisputed that there was a disclosure. And we also, through sworn testimony, established that there's no prior relationship between my clients and Mr. Hamilton. And both the DC Superior Court in Battle and every single other court that has addressed this issue, it really does matter. There has to be some kind of animus, personal grudge, the misuse of the statute.
So if I'm correct, your position maybe is a little bit narrower than I thought you are articulating, right? Your argument is not necessarily that you're automatically immune, and so therefore the case should have been dismissed, or you should have been granted summary judgment. Your argument is because you had immunity and there was no evidence put forward to rebut the presumption of good faith, the case should have gone away.
I agree with the last part, Your Honor. I think it was more of my decision to wait and not file a motion to dismiss was based in part upon the Battle decision, where I think that the court in that decision said, well, this maybe have some facts, maybe they should produce some facts in discovery that bears upon whether or not the presumption of good faith has been rebutted. And so based upon that, and based upon the other cases that I've published, decisions that I've read, I thought it would be prudent not just to frame the issue in the four corners of the complaint, which the trial court would have to take as true, correct? So I thought it would be more beneficial to us to rely on the statutory presumption, point out that they haven't adduced any evidence in all discovery rebutting the presumption, and also we're putting forth affirmative facts showing that there was no bad faith on the part of my clients.
Can I ask you again? I asked you this before, but I want to ask a more specific question about the second prong involving how separate the issue is from the merits of the merits of the case. And I think you said sort of generally there's a case that says there's always some overlap, but it has to be this prong has to mean something. There have to be some cases that don't meet this prong, and here it seems like it's relevant that that the merits of the underlying case involve issues of negligence, and that the immunity issue, the important issue, involve issues of bad faith, as well as, other legal aspects of it. But why, aside from just some cases say there's a lot of overlap, why isn't this a problem under prong 2?
And it is not, and I think Your Honor raises, and I apologize if I didn't answer the question to begin with.
You probably did, and I just didn't hear you. But
Good faith, it is universally accepted that good faith and negligence is not bad faith. It has to be something more. This court has repeatedly ruled that in other cases, and other courts interpreting their mandatory reporter immunity statutes say it. So to equate negligence with that bad faith or the lack of good faith it's not. They don't overlap, Your Honor. So that would be one thing. The key is it's the merits, the prima facie elements of medical malpractice, of negligence, of intentional infliction of emotional distress. You throw up your hands in the air and say outrageous. That's not the same analysis as whether or not good faith exists under the statute, or whether the statutory presumption of good faith has been rebutted. Negligence alone cannot rebut the statutory presumption of good faith. And I'll read to you what Justice on that issue.
Do you have a case sort of talking about this? Because right under the second prong of the collateral order doctrine, I didn't understand the question to be whether or not the legal analysis maps on all fours. I thought the question was whether or not the immunity question was separable from the merits. And what I thought Judge Beckwith was asking is sort of why aren't these intertwined? But are you saying that that's not the way we look at it under prong 2?
When I said there's some overlap, obviously some of the same facts. So you got to look at some of the same facts when you're determining good faith. You're looking at the party's conduct, as you do it when you're looking at the merits of the substantive prima facie claim, elements of the claim, and the defenses. So that's what I mean by some overlap. But quote, this is Mitchell v. Forsyth. The test is conceptually distinct from the merits of the separate and apart from the merits of the plaintiff's claims. Whether good faith exists has nothing to do with whether or not they can establish the merits of their substantive claims.
So you see this issue here as basically the same as the sovereign immunity questions?
Yes, ma'am. I don't see any difference between that, the sovereign immunity cases, the anti-SLAPP, or, for that matter, judicial proceedings privilege. In Finkelstein, this court recognized that it satisfied the collateral order doctrine, but what happened was that the Supreme Court and Will v. Halleck in 2006 clarified that the third prong has to include a provision that there is a substantial societal interest. And in McNair, this court reassessed the judicial proceedings privilege and said that that's not a substantial societal interest. I don't think in this case, the DC's prevention of child abuse and neglect statute and the immunity that is a component of it can be said that it is not a substantial policy societal interest. And I think that's why it satisfies all three prongs. Unless your honors have some more questions for me.
Thank you. We will give you a couple minutes on rebuttal. Thank you
very much.
Morning.
Let me first go ahead and address the question about the second sentence in the statute. I appreciate the court's question there. I don't even think counsel disagrees with this, but that statute refers to the subsequent proceedings that would happen in the domestic relations matter. So if the mandatory reporter, that liability, the immunity from liability would apply toward her testimony in a domestic relations matter or.
How do you reconcile that with the use of any? It's immunity in any judicial proceeding involving the report. So if you sue someone for negligence for filing a report or sue someone for defamation for filing a report, that seems to be a judicial proceeding involving the report.
Yeah, I mean, I understand that for that reading to be correct, that would completely negate the good faith and reasonable cause elements to the statute. I mean, there's no.
Sorry, how is that? Because the first sentence presumes that there's good faith, right? And so as long as you have participated in good faith, then you have this immunity with respect to any type of judicial proceeding that might come out of it. And then there's a presumption of good faith, and then it would be on the person trying to get around the immunity to file the defamation or the negligence to allege in their complaint bad faith, correct?
Okay, there's a couple different questions here. I mean, the participation, that second sentence, I think if you say that applies to a subsequent lawsuit outside of the domestic relations matter, outside of a child protective services matter, then it's essentially an immunity from suit when the language in the statute says immunity from liability, and it requires that the report be made in good faith and that the person have reasonable cause to make such a report. And so if you say that if you inflate any judicial proceeding to mean a subsequent negligence matter for malpractice, the statute wouldn't have any, the good faith wouldn't have any meaning. That's what this case is
Report
about.
in bad faith, then you wouldn't be immune. So if you alleged in a negligence suit, you made this report in bad faith because we're neighbors and have a dispute over a fence, then you would perhaps have rebutted the presumption of good faith and could be allowed to proceed with your defamation or negligence suit.
Okay, I mean, I think that's fine. Yeah, either way, I would disagree that second sentence goes towards the case at bar here. I do think that applies to the negligence, to the domestic relations cases, but.
Are there any other are there any other statutes with similar language or cases involving that language that you can point to?
Like I said, the two cases that we cited from outside of the jurisdiction, the Montoya case and the Utah and the Colorado cases, I mean, those are pretty much identical facts to what we're doing. And the analysis there, I think, is spot on regarding, what the good faith is not just this automatic presumption that can't be rebutted. It's a rebuttable presumption. The other statutes.
I don't think anybody's saying that good faith can't be rebutted. We're just asking, when does it need to be rebutted? And what happens if you fail to rebut it? If at trial we fail to rebut the presumption, it's a factual question, which Judge Williams found.
But wouldn't it have to be before trial, right? Because otherwise, what's the point of the second sentence? I mean, I understand you have a view of the second sentence, that it only applies to the proceedings that directly flow from the report, but I think any judicial proceeding is broader than that. So if you accept that any judicial proceeding really means any judicial proceeding, then why wouldn't you have to show I'm getting confused with why wouldn't you be entitled to get the case dismissed before trial?
I suppose.
Absent a showing of good faith.
Sure.
Or bad faith.
Right.
Lack of
and so, if you look at the battle case, the unreported case, there's a situation where the plaintiff didn't allege bad faith. And so in that situation, that would be appropriate. I think the court's dismissal was appropriate.
With all due respect to the trial court, battle's like a dot on the map, right? So it doesn't really help us when we're line drawing, right? Because you need at least two dots to draw a line. So, and usually those dots have to be drawn by this court. So, I'm just trying to understand how you want us to interpret this statute. I guess I have another question. What do you think the burden is? By what measure do you think you have to show a lack of good faith? preponderance of the evidence?
I mean, I think that is, I don't know that we have to do, I think we have to make allegations that in the light most favorable to the plaintiff, if, you know, would rebut the presumption. And so here we've got two expert reports and we have
Let's say I think you need to do that in the complaint because it's an immunity from suit. Where in your complaint do you allege bad faith as opposed to mere negligence?
I know it's in the complaint. I don't have that in front of me right now, but we've alleged bad faith in the complaint for sure. All of her actions, everything she's done constitutes bad.
Negligence. I don't see the words bad faith anywhere in your complaint.
The allegations that we've made, I'm quite certain is in there, but I'll defer to the court. I don't think there's any dispute that we've alleged bad faith here. And I think the important distinction to make between this case and the other cases that counsel cites on sovereign immunity, judicial proceedings, and the anti-SLAPP, those cases, none of those cases have good faith in their statute. I mean, clearly anti-SLAPP is a liability from suit. That's the whole purpose of an anti-SLAPP law.
So just picking up on Judge Ali Khan's question, do you think this immunity is self-executing? I mean, if you sue a mandatory reporter and they don't invoke the immunity from liability at the outset, do you think it's the trial court's obligation to say, well, here's the statute and you didn't allege lack of good faith, so I'm dismissing the suit?
I'm not sure I understand the question. Can you repeat it again?
If you sue a mandatory reporter,
Okay.
and there's an answer to the complaint, and the answer doesn't raise the immunity question, right? And you haven't raised lack of good faith in your complaint. Do you think that the statute is self-executing, that the trial judge has to dismiss the complaint absent the issue being litigated?
No, I mean, I think it would depend on what.
So if it comes up later, say on summary judgment,
Right. I mean,
then
if
it could be litigated at that juncture.
Absolutely, yeah.
Or do you think it's been waived?
I don't think it's been waived. I think that the facts, you know,
The immunity being, you don't think the immunity has been waived? You think that a mandatory reporter could still say in summary judgment, okay, look, they didn't allege, I didn't say anything about immunity in my answer. They didn't say anything about lack of good faith in their complaint. I'd like to talk about this now. Now I want to assert immunity, and that could be heard at that juncture.
Honestly, I didn't give that hypothetical a lot of thought, since that's not what we have in this case. I'm not sure the answer to that. I think I would sort of tend to lean that it is self-executing. I think it's still, you know, it's an immunity from liability. So at trial, they could raise their immunity from
It's
liability.
like a surprising position for you to be taking because like qualified immunity, for example, it's well established, it's an affirmative defense and it can be waived. And so given your friend on the other side's decision not to file a motion to dismiss, I would think you'd be taking the position that it had been waived here.
I don't know. I mean, that's not a position, but I mean, you may be correct. I mean, I'll defer to the court on.
Well, I mean, I suppose
that's-
you then can waive the waiver, right? So if you don't think that he has waived immunity.
I mean, I guess if he hasn't argued immunity in his answer, then there would be an argument that he's waived immunity. That's a fair assessment. But I think going back sort of to the collateral order doctrine and also just, the argument essentially is that we haven't put enough facts forward to allege bad faith. And the trial court disagreed, our trial court. But, and I don't know, if what we've put forth doesn't constitute a showing to make this a factual dispute that in the light most favorable to the plaintiff gets us through to trial, then I mean, there's just no meaning to the good faith requirement.
How do you define, or how would you personally define bad faith? And do you think of it as is it purely subjective, or, you know, how do you go about establishing it?
I think if there's an ulterior motive, right? I mean, if there's, you know, if the reason for reporting is not simply for the protection of the child, your reporting is done in bad faith here.
And what is your allegation that that was the case here?
Because she is serving as the mother's expert witness.
We're looking at the time that she made the disclosure, right? And I thought your client conceded that at that point, there was no relationship between him and the therapist, let alone some sort of animosity.
No. So at the moment that Ms. GERACI is hired, she is hired to represent mom, to be mom's expert witness. 3 days after this alleged report, she's in court and they're qualifying her as the expert. She was retained to be the expert and also the treating therapist. That's a massive conflict.
But doesn't, I'm sorry if I don't understand the timeline, doesn't that happen all after the report is made?
No, she even writes a letter to the court before beginning treatment with the child,
But
suggesting
after making her report,
what?
after calling CFSA.
No, it's before. 100% before. The letter was sent before she even met the child for a therapy session. They'd only done an intake. The report by the child, the so-called report, that hadn't even occurred. So that letter, that massively inappropriate letter that even the defense counsel's own expert admits was inappropriate, was issued before she even started treating the child. And I mean, nothing, and just to turn the court to Judge Becker, and once again, Judge Becker is the trial court judge in the domestic relations matter. I mean, Ms. GERACI, who brought her own significant bias to this case, right? I mean, this is the language that is so strong in that the trial court found after a 14-day trial. You know, from the start, Ms. GERACI's work with SCH has conformed to none of the best practices. Instead, she's been essentially an advocate for Ms. Razaka and for the notion that SCH was sexually abused, that her work has been fatally compromised as a result. That's the trial court's findings.
So I
At
just,
the domestic relations matter. That alone,
we'll
I think
certainly
is
go
enough.
back and look at the record, but I just because I'm sure Ms. GERACI's counsel is going to get back up and dispute the timeline. Can you just give us the date of the letter sent to the court, and then the date of starting treatment and the date that the report is made? Just those 3 dates.
I believe the date of the letter was 2 or 3 days prior to the September 8th session where the child was held captive for 90 minutes, including, you know, there's a 3-year-old child that's kept in a room for 60 minutes to try and get a report out of her. And then when that doesn't work, mom and a friend keep her in the waiting room for another
And
30 minutes.
The session's on the 8th. The report is on the next morning, the 9th. Is that correct?
I believe, but the letter,
And the letter is written on what date? You think it's
I
like
believe
the
the letter
6th or
was on the
something?
6th. I don't believe that issue is in dispute at all.
But at the time of the letter, the therapist had already been in contact with MPD and was aware that there were allegations.
Right, so she'd spoken to the mother and the MPD detective who had also only spoken to the mother. That's it, and no charges had been even contemplated. So, right, I mean, I think it's, I sort of want to get back to I mean, these are just some of the multitude of facts that we have put forth and the expert opinions that, I mean, it's a factual dispute. This is a factual dispute. And those facts, whether you agree with the weight that they have, they at this moment, I don't think you can. The weight is seen in the light most favorable to the plaintiff. But regardless, the issue here that we're all arguing and debating about is essentially what, you know, violates prong 2 of the collateral order doctrine, because they're completely intertwined. This isn't a separate legal issue. This is a factual dispute over good faith, bad faith. And that's for a trial to determine. These other immunity statutes don't have good faith language.
Is it your position that the collateral order doctrine in DC should just be limited to the cases we have, the anti-SLAPP context, and sovereign immunity context, and that's it? You know, whatever else is covered that isn't this situation?
I think a line can be drawn in this regard between immunity from suit and immunity from liability. I think that's
And
as
your
far as
opponent,
the collateral order doctrine.
your opponent says those issues as to prong 2 are completely separate. Can you say a little more about why that's not correct in your mind?
Right, because what we're alleging is that the defendant didn't act in good faith, nor did she have reasonable cause to suspect that there was child abuse. She didn't have reasonable cause to make the report, and the report that she made was done in bad faith. And all of the things that she does, not assessing the child, keeping her in the, you know, multiple sessions right off the bat, keeping her in a session for 90 minutes. You know, and these are all findings that the domestic relations court removed her as a therapist and, you know, did a complete 180 where now dad has tie-breaking authority on any mental health decisions. That's how bad Miss Geraci was.
That could be a determination based on negligence, right? And it seems like your friend on the other side does not dispute that there might be medical malpractice claims against his client that survive. I guess it's just, that to me just seems to be a very distinct question from the statutory immunity question.
Whether the facts are significant enough to be bad faith more than negligence is a trial court decision. And that's not a decision that can be made based on counsel's opinions, which is essentially what
I think we've been talking today about, you know, other immunity statutes and other types of immunity. Qualified immunity is one that is an immunity from suit, not just immunity from liability. And there it protects against a variety of constitutional violations. And there's a question of whether it was a knowing constitutional violation. That also seems like a fact question, but that has never prevented a court from deciding it early at the motion to dismiss stage. No one's ever thought that that was a trial question.
But I'm not aware of a case where that was contested. And that's why. You know, some of these statutes do have, like the judicial proceedings, if what was said was completely irrelevant to the proceeding, in that case, you wouldn't have the judicial proceedings. But in the cases where the judicial proceedings immunity is looked at from the collateral order doctrine perspective, there's no allegation that the statement made was not relevant to, so that qualifying language isn't there. I mean, to find for the defense here, it would be taking away the checks and balances the legislator put into this statute. And this is also a massive, massive problem in the domestic relations.
If it were a massive problem, I would expect that we would have some case law on this. But it seems to me that the council, or perhaps it was even Congress, I forget when the statute was first passed, was striking a careful balance. They were saying to this class of professionals, you are mandatory reporters. And if you fail to report a credible or reasonable allegation, I forget what the terminology is, you yourself can be held liable. And so in exchange for that enormous threat that we're putting on you to get you to report, we're going to give you on the flip side immunity if someone tries to sue you because they think you made this negligently or without sufficient, discussion with the child, right? And that the only time in which you'd be able to be sued is if it really does rise to the level of bad faith, meaning that there was not a credible allegation and you had reason to know that. You were doing it because you were trying to get back at the person who you were making the allegation against. It just seems like, we have to sort of look at this in the full context of the benefits and burdens that the legislature was putting on this class of professionals.
Sure, and it's a factual dispute. You look at the case before us, that father, don't waste your money appealing, arguing in trial. Just go hire a social worker to be your expert and have her say that I think there was abuse. I just saved you $20,000, $30,000 from having to go file an appeal and argue this. It's that simple. Because if we read the statute the way people are proposing to read that, you don't have to have good faith. You could just, as long as you get a social worker to say it, you're good to go.
Well, no, the social worker has to say it in good faith. And if you have reason to believe they were a hired gun, were making up, fabricating this claim, then you would allege that in your complaint. And then I think you would then perhaps get past a motion to dismiss.
Okay. And I believe we alleged in the complaint that she was serving as mom's expert. The date of the letter was August 31st. It's undisputed. That she was acting as mother's expert, and that's a conflict. The two experts on our opinion have both opined that is a conflict. Just think about that, right? You're supposed to be treating this child, but also your mom's expert witness. You want to deliver for mom. She also had, this is a woman that at the time was in financial, has $116,000 debt to the IRS. She, is getting get little games with the victim of crimes panel. The child wasn't a victim of the crime, and all of these things, and then making false reports to Mr. Hamilton's insurance company. It just keeps going and going and going, which is why the domestic relations judge. I can't think of any case where I've ever seen a domestic relations judge go this far to say how atrocious the Miss Geraci was, that she removes the child's therapist. She finds that she had bias, and bias is got to be a factor for good faith, right? And that's got to be a triable issue here. And so, I think to sum up, I think I'm over my time. The collateral order doctrine can't be found here because this is not immunity from suit. This is immunity from liability, and there is good faith and reasonable cause language that has been challenged, that we've raised and objected and argued does not apply here. That she did not act in bad faith, nor did she have reasonable cause. And so for those reasons, I don't think the collateral order doctrine applied, but certainly the question of whether she acted in good faith or bad faith is a question of fact that is for the trial judge to determine. Thank you. Appreciate it.
Thank you very much, Mr. Gowan. Is that right? Okay. Mr. Lee, we will give you 3 minutes.
Thank you very much, Your Honor. To address the second prong issue again, I'll read, and forgive me for doing this, but I'll read from the Neschflegler case. As to the second criterion, sovereign immunity is an important question separate from the merits of the case. In Mitchell v. Forsyth, the Supreme Court explained that immunity is in part an entitlement not to be forced to litigate the consequences of official conduct, so that a claim of immunity is conceptually distinct from the merits of the plaintiff's claim that his rights have been violated.
Sorry, that's a sovereign immunity case, as the quoted passage indicates.
Well,
we've got a statute that says, yes, you can be immune from liability or suit, some dispute about that. But unless it's rebutted by a showing of lack of good faith.
Right.
So
Your
that
Honor,
seems, I'm not sure how a sovereign immunity case helps us.
well, sovereign immunity is not absolute. Obviously, there has to be a determination, factually speaking, whether or not it was ministerial discretion. Just because you're a government employee and commit a tort doesn't mean you're entitled to sovereign immunity. There's always some questions of whether or not immunity applies to a specific given case.
Okay, you're taking me down a different rabbit hole, and I'm just trying to focus on good faith or lack of good faith in the context of the collateral order doctrine, and I'm still not seeing how that case is helpful to you.
Well, the Mitchell
Or to us.
Forsyth case was not a sovereign immunity case from which this court quoted. It was a qualified immunity defense by law enforcement or
Right.
by law
And
enforcement.
qualified immunity generally involves like whether or not the law was clear. So it's not necessarily a good faith, bad faith question. So I'm still, we have a statute that says, you know, if you show a lack of good faith, you are not barred from suing a mandatory reporter. Right.
Well, the statute requires you to rebut it. And as your honor.
Right.
Yes.
So, I mean, let's talk about that. Right. So I walk into a mandatory reporter and I say, you know, my child has been sexually abused, and the mandatory reporter doesn't speak to the child and just says, give me $10,000 and I'll make a report. Do you think at that juncture that you could put forward that evidence to say there's a lack of good faith, that they never talked to the kid? You know, they took this exorbitant fee. That shows that some showing of a lack of good faith in this mandatory report. I should not be barred. Do you think is that enough to get beyond?
I don't think so. And
You don't think so?
I don't think it's sufficient to rebut. And I don't think that those are the facts of this case.
I'm trying to figure out where your lines are, right? Well, that's what we do up here is we draw lines. So
Right.
if I walk into a mandatory reporter and the mandatory reporter says, all I need is $10,000 and you tell me what you think happened to your child and I'll make a report, that's not enough to make a showing of a lack of good faith.
I think that probably is sufficient, Your Honor. Yes.
Okay. So here, you know, our facts are a little bit different. The mother goes in and says, here's my account of what happened to my daughter, what my daughter told me, perhaps coached. And now I want you to talk to my daughter. And I think initially she talks to the daughter and the daughter doesn't say anything, right? And then they stay, and then perhaps, I mean, there's sort of allegations of potential, an opportunity for more coaching. They're there in the waiting room for a very long time. And then the mother says, now she's ready to tell you what happened. So you don't think that's enough to say, oh, there's a lack of good faith here? You know?
I think, Your Honor, I believe it was you, Your Honor, who pointed out that Detective Hemmer, the investigating officer, had talked to my client prior to the inception of treatment. There was no doubt that people knew that these were the allegations.
But I thought your colleague, I thought counsel for Mr. Hamilton said, look, the detective had just talked to the mother. It's a closed loop, right? All the information is coming from the mother.
Of course, Your Honor.
Right, there's a contentious divorce.
Right, but
There are two people who don't
no-
like each other, don't want to be married to each other, and want to have custody of their child. And there's one person who is the source, arguably. If you look at the facts in the light most favorable to the plaintiff, who would like to pursue his case, who's saying the mother is the source of all of this.
No.
And she feeds this information to your client before the report is ever made.
Your Honor, this court found in the Pendente Lite hearing prior to the inception of treatment that there was no dispute that in May of 2017, the daughter said she performed oral sex on her father and did so in front of her father and her mother. The father did not dispute that. So
Did not dispute that she said that.
exactly. Obviously, you know, he disputes that it occurred, but to say that it was a closed loop and just from the mom that's not what these facts are. And indeed, Judge Becker later on said it was undisputed that she said it in May. It was undisputed that she said it in September. It was undisputed that she said it in October during the forensic interview in front of a detective, CFSA, and Safe Shores, the multi-jurisdictional team. So obviously my client knew coming in that she was seeking there.
Not to get too pointed, but the conversation in May, was it quite as graphic as it was when after in the alleged report.
No, Your
Right.
Honor.
There's use of some language that is not precise anatomical language.
Well, the evidentiary findings in the divorce case was that she used the word bum bum, which the family used or associated with male genitalia. The difference between the disclosure in May of 2017 and the disclosure to my client in September of 2017 was that the girl picked out a cactus
Right.
figurine and then
Right.
performed
We
oral
don't
sex.
necessarily need to go into the details of that. We're
But-
familiar with that.
But
So
the allegations.
that was not part of the conversation back in May.
No, but
No.
certainly the allegation was oral sex. And Your Honor asked about the burden for rebutting the presumption. I would suggest it was not discussed by the lower court. I would suggest to this court that it should be the greater weight of the evidence, which is the normal standard burden of proof in a civil case, short of fraud or some other extraordinary tort, so that they would have to prove by a preponderance of the evidence that they have rebutted the statutory presumption of good faith.
What do you make of the fact that qualified immunity is an affirmative defense that is waived if not raised? And you say you chose not to file a motion to dismiss. Have you arguably waived the question of immunity?
No, Your Honor.
Why not?
We raised it as an affirmative defense in our answer. And it was fully litigated throughout discovery. Everybody knew what was coming at the end of discovery. The only statute that I'm aware of that forces the litigants to raise immunity right away is the anti-SLAPP statute. It has a deadline that requires the parties to do certain things or else it is waived. And that's expressly set forth in the anti-SLAPP statute. If you don't file the special motion to dismiss, then you've waived the ability to do so. This statute does not have that same provision. And I think the statute, the anti-SLAPP statute, actually requires the court to act in an expeditious manner in ruling on that particular case. The letter, I'll go back to it. If you read the letter, it's a illogical leap. All she said, all the letter said, it never actually got to the judge. All the letter said, I have initiated therapy with this young girl. Please give me time to do therapy. Didn't accuse Mr. Hamilton of anything.
I don't know if that's the fairest reading of the letter. I mean, the letter does say, like, I have not started treating this child, but there have been reports of this, and I would not want her to go with her alleged abuser.
Well, Your Honor, yes. And so as far as the letter goes, it again, though, is not something that's a personal animus or shows any kind of a grudge or that she's.
It would seem to indicate some prejudgment.
Perhaps, but if that prejudgment is in protection of a 3-year-old child, rather than if you view it in that light, then I think that's where my client was coming from. If you're going to infer or read into language in a letter that there was some personal animus or lack of good faith relative to the father, I can also tell you that my client, being a licensed clinical social worker for the past 30 years, who primarily did treat with patients until this case, minor patients until this case, felt that the best interest of the child were paramount in this case, hence the letter. If the court doesn't have any further questions for me, that concludes my presentation. I thank you all for your time.
Thank you very much, Mr. Lee. Thank you, Mr. Goen. The case will be submitted, and right now we are going to take a short recess to reconstitute the panel.
All right. This court takes a short recess.
Do we know how long short recess? Do we know how long the time frame for the rest?
Just a few minutes.
Line a little bit after that too.
All right. This court is in session, please be seated and come forward.
Hello again. Thanks for sticking with us. So our third case on the calendar is Karen Hill et al. Versus Capital Digestive Care LLC et al. It is case number 22 CV 354. So counsel, when you're ready, come on up.
Thank you, Your Honor. Good morning. My name is Matthew Nace. I represent the plaintiffs in this matter and the appellants. Procedurally, if I could reserve 4 minutes for rebuttal on my time, be appreciated. I'm gonna avoid the facts because I understand the court is very well versed in them. But essentially what we're talking about here is a medical malpractice case along with an informed consent case in which Mr. Hankins presented in January to the defendants for a follow-up on diverticulitis issue and was then scheduled for a upper endoscopy and a lower endoscopy that happened on March 1st. There's been a finding of fact by the underlying court, the jury, that Dr. Bolin both deviated from the standard of care and failed to obtain informed consent. The issue here comes to the questions of causation. And
So, counsel, we're familiar with facts and procedural history. As I understand it, you have a couple of arguments that are related to the verdict form.
correct.
And my question preliminarily is, why do you think these claims are properly before us? I'll be more pointed and say, I think some facts are omitted from the account of the procedural history in the brief. Because if you're talking about the inclusion of the proximate cause question, I certainly see that Ms. Hill submitted a verdict form that just said cause. And I see that Capital Digestive Care and Dr. Bolin submitted a verdict form that said proximately caused. And I see that the trial court initially adopted the language proximately caused. And then I see, and this is what I don't see in the brief, but I see that Ms. Hill asked for the proximately caused language to be changed to a proximate cause. And I see that the trial court said, okay, I'll do that. And then it actually failed to do that. And then Ms. Hill reminded the court to do it. And then the court made the change, and that was the verdict form that went before to the jury. Am I mistaken about these facts?
I think what is missed from those facts is that, again, when we take into consideration the COVID pandemic on this and the
I'm
manner
really
in which
not
things
quite sure
happen.
what the COVID
Well,
pandemic
right.
has to do with any of this. It's
Well-
all documented. I mean, there's a
Right.
conversation over a course of months. And so I'm trying to ask, what did I miss in the dialogue that happened about the verdict form?
What was missed is when we get to the portion of the trial where we finally get to argue the verdict form.
And
The
what date would you say was that when you finally get to argue it?
Oh, that was not until the final date, which I believe was September 9th or September 8th, I'm sorry. After closing arguments had been concluded, the jury had been impaneled and were deliberated. The jury is already in the deliberations room when they send an initial question to us saying, when are we going to get a verdict form? And so we were in the process of negotiating that verdict form.
I thought you sent a verdict form, right? There's a hearing, or there's a conversation on September 7th where you're talking about the verdict form and you're talking about other things, right? At this point, the approximate cause, at least for the negligence claim, and we haven't even talked about the informed consent part of the verdict form, but the approximate cause language is in the verdict form, and no one seems to be talking about that anymore. The conversation has moved on to other things about assumption of risk and the order of the questions and how are we going to tell the jury to navigate through the verdict form, right? Those are all the things that you're talking about. And the court says on September 7th, please get together. Please give me a verdict form that you all can agree on or show me your disagreements. And then you do. And an email is sent that evening that, granted, I agree, it comes from Dr. Bolin, but it is clearly responsive to the directive of the court telling the parties, please get together and send me something. And so at appendix 340 through 343, or 342. There are all the questions that you seem to have agreed upon, and then there are counter proposals for various other questions for 7 and 8. But there's nothing about 2, nor for that matter, is there anything about 4. So
Well-
at that point, I mean, and then the jury says, can we have a verdict form? And the court resolves these other questions and gives them a verdict form. But I don't see anywhere where, at least, I mean, sticking just to negligence, where there's an objection to, in fact, there seems to be acquiescence to a proximate cause. It is your proposal to change proximately caused to a proximate cause.
So to back up on the factual issues that you just addressed, at page 1310, it was not the court's order for us to come up with a joint verdict form. The proposal was made at 1310 line 15 by defense counsel, indicating that taking a break at that time would allow the parties to try to work together on some of the issues. There was extensive conversations.
Wait, I'm looking at 112 or 1112 through 1013, 1113, right? The court says, I'm going to ask if both sides could get together and make the proposal that suits you both, so we don't necessarily need to go to argument on this, right? So would you both consider drafting jointly and letting me know where you disagree? Right?
And then,
And that's what happens that evening.
so, but I don't think that's a fair representation of the facts of what happened, is because what was submitted was not agreed to. We were supposed to argue.
No, it
the
wasn't.
actual-
It showed some questions over which there seemed to be no dispute. And then there were proposals and counter proposals for certain
that-
questions, but those questions were 7 and 8. And there was nothing about 2 or 4.
And then I specifically asked the court, because I had raised
This is where you're going to tell me that you asked to preserve all prior objections, but the problem
But-
is that doesn't help you if you didn't object to this before.
but I did at 1330. Because the court needs to remember that what happened here was defense counsel came in that morning, the same morning, I think on the 8th, I believe. And at page 1330,
Can you tell me, there's so many appendices, so it would
This would
be
be
helpful to
volume
tell me
4.
which.
volume 4, it's right at the beginning of volume 4. And at 1330, we're still arguing jury instructions. And counsel, and this is part of the issue in this case, counsel for defendant comes in and now wants to amend the informed consent jury instruction to add yet another question requiring a jury to make a finding of informed consent of causation. I end up losing that argument, and the insertion is made by the court to add into the informed consent pattern jury instruction more causation deliberation. And I say on 1330, I think that repetitively repeating the same thing turns us into a prejudicial verdict form, and it changes the focus of the jury instructions, and it changes the focus of the jury instructions. So when I get to the end, when the jury has come back with a question, and when we're getting a verdict form, the court made it clear that she wanted to get the jury a verdict form, and no one could dispute that. They've been debating already on the issues. So that's why I said to the court, I presume my objections are all maintained. We had been discussing this, everybody in the courtroom.
I
knew.
just don't see where you're discussing a proximate cause versus proximate cause. Nor do I see where you objected to inclusion of proximate cause with respect to informed consent. Right? That's just not what this conversation is about here.
But, and that's the point, and we never got to that point. And this goes back to,
Well, that's a different argument. If you never got to the point, then you didn't make the objection.
I never got to, because the judge told me on multiple occasions, she told all parties to stop objecting. To
No,
get
she
to the
said,
point.
stop making the objections that you've already made, but you're trying to tell me that now you were renewing an objection that you hadn't made because you never got to it.
The objection had been made from from the initial submission of verdict forms
Okay.
that I'd already lost that argument.
But you don't lose, if you put forward a form that says they have to show it caused the harm. And then the other side says, well, we'd like it to say proximately caused. And then you say, how about a proximate cause? That doesn't raise an objection. That's a conversation and a dialogue where it seems like you end up meeting in the middle. There's at no point where you say, we absolutely disagree that proximate cause should be a concept in this case. But if it has to be, then we want it to say a proximate cause. That's the conversation that didn't happen. And so, I mean, what I hear you saying is that you preserved it because you put forward a verdict form months prior that said cause. But that doesn't preserve the objection if you never indicate that you don't really care whether it says cause or proximate cause.
And I would simply say that I think when the jury, it was understood by me that when the jury said numerous times, your objections are preserved, that they were all preserved. And I think this goes to the Weissman v. Middleton case, which we cited as well, which specifically says, where it's apparent from the face of the record that a miscarriage of justice has occurred, we properly may reverse based on an error in which no
Why would we
objection.
find there's a miscarriage of justice if it seemed like you proposed the language?
I don't know how I proposed the language.
When the court said proximately caused, you proposed a proximate cause, and the court adopted that language.
Because the distinction was that I had lost the issue on proximate cause versus cause.
Okay,
But it was not, but what I was.
Maybe when you sit down, I don't mean to, as one of my colleagues says, feed a fed horse, but maybe you can tell me where you lost the debate, because I just don't see where the loss was. What I see is a conversation, which happens all the time, where parties go back and forth and settle on language. And I don't see an actual objection to the concept of proximate cause, but we're down now to 2.5 minutes of your argument, and we haven't gotten to what I think maybe are the more complicated issues of contributory negligence. So do you want to speak to that?
I would love to. And I would say, first of all, that there is a specific Supreme Court case on the issue of the proximate cause as well that we rely on. As for
That's only if we get to the merits.
Correct.
Right.
As for the contributory negligence case, multiple issues have been brought up, but Durfee v. Kaiser Foundation is what's important here, where defendants are trying to say that Mr. Hankins did something before treatment that he was getting treated for as negligence. And what Durfee says is it distinguishes between a contemporaneous and the Judson test. Judson test being significant contribution to the injury. But what it also says specifically is a patient's non-cooperation with the doctor's instructions after the doctor's alleged negligent act and subsequent negligence of the patient, which aggravates the injury primarily sustained at the hands of the physician, does not discharge the physicians from liability, but only goes to mitigation of damages. So what defendants tried to argue for contributory negligence was that in January, he didn't say that he had PADs, stent, Plavix, or aspirin. There's no causation to say that the failure to disclose PAD, peripheral artery disease, or stents caused anything to happen. The only argument is that afterwards, he failed to continue his aspirin treatment.
But
Well, he stopped his
before
act-
the procedure, he,
Before the procedure and continuing afterwards.
right, and so the quote that you just read goes to noncompliance after the procedure. Here, he did something before the procedure.
Which was cured when he showed up on the day of the procedure and said, here's my medication list. Here's what I'm taking, here's what I'm not taking. Dr. Boland specifically said, if he looked at that, he would have advised the plaintiff of the risks and benefits. He would have had a conversation. He would not have done the procedure, or if he did the procedure, he would not have taken out Apollo. At the end of the day, there's no, every doctor, everyone agrees that the discontinuation of Plavix was a cause of the development of a clot. Defendants want to
Well, I
rely.
thought every doctor agreed that it was the discontinuation of the Plavix and the aspirin, right? Because everybody says, look, you shouldn't do this procedure while someone's on Plavix. So the fact that the patient discontinued Plavix before the procedure, seemingly on his own, we have no idea why, but it's undisputed that he did discontinue, seems to be like maybe a good thing. Like that's definitely a non-negligent thing, but he also discontinued the aspirin, right? Which wouldn't have been what was recommended. And in fact, when Dr. Bolin gave the post-op instructions, he said, continue the aspirin. So it seems like there's just this. Okay.
That was disputed in the discharge form. The
Okay.
discharge form specifically said.
But there is evidence.
Yes,
Right. And now we've got a jury verdict.
correct.
So I'm not sure how we get underneath that, but so this all seems intertwined, right? The discontinuation of the aspirin, the discontinuation of the Plavix, which is definitely non-negligent, but the Plavix runs out 5 to 7 days. He starts experiencing symptoms around day 5 after the procedure. He hasn't been taking the aspirin for now 7 days, right? I don't see how Durfee helps us with this. This all
Because-
seems to be intermixed, and it's not. This isn't like a preceding act, and it's not a subsequent act. It's all of a piece,
But there's also.
or a jury could find,
Correct.
right? That's really the question. It's like, I mean, we're not here to sit as the 13th juror, but a
Correct.
jury could find.
The issue is more to the proximate cause nature and the jury instructions on informed consent. But to answer your question, though.
But if we're beyond the jury form, and now we're just talking about the sufficiency of the evidence for contributory negligence to go to the jury, right? I thought that was the next set of arguments, right?
Well, yes, but also.
I'm asking you to put aside the verdict form
I think.
and
there's
focus on the contributory negligence and your argument that the contributory negligence never should have gone to the jury as an evidentiary matter.
Because Dr. Miller testified that there's two issues at play here. There's arthrosclerosis, which is the inflammation of the vessels, and there's clotting. And he was given the opportunity to testify that aspirin would have stopped the clotting. He did not say that at 9:23. He said, my opinion is that had Mr. Hankins resumed aspirin the day that Dr. Bolin suggested that the colonoscopy, right after the colonoscopy, more likely than not, the patient would not have had the occurrence of his lower extremity arthrosclerosis. That
Right,
is
you're
not.
focusing on Dr. Miller's testimony, which you also argue never should have been admitted, but I thought that there was other expert testimony about the discontinuation of the aspirin from your own experts. So don't put aside Dr. Miller, because Dr. Miller seems complicated.
Well, my expert, Dr. Jim, testified to. Counsel tried to use impeachment for his testimony, but counsel did not.
Your expert testified that had Mr. Hankins remained on aspirin from February 28th through March 6th, more likely than not, he would have been able to avoid the occlusion.
As testified right before that, that was deposition testimony attempted to use for impeachment. On rebuttal, the very next question in that deposition was, this is found at 795. Look at your deposition on page 135. You were asked about aspirin. And the very next question that you were asked by Mr. Goodson, it says on line 136, line 4, is it accurate that whether he was taking aspirin or not, if he had taken the Plavix beginning back on following the procedure on March 1st, that more likely than not, he would not have had the occlusion? And your answer was yes. Is that still your testimony today? Yes. Dr. Jim did not testify. He testified that aspirin was beneficial.
It wasn't just Dr. Jim, and I'll go back and look at that passage that you just read. Right, there was another expert who testified that the aspirin would have more likely than not prevented it, right? Prevented the occlusion.
And again, that the aspirin doesn't affect contributory negligence. It doesn't. What needs to be addressed here is the failure
The discontinuation of the aspirin. Why not?
because as Durfee
Is it
says,
just because it's
that's-
proceeding?
and it's a mitigation of damages, but also because
But it's only mitigation of damages if it's after the fact. We're talking about his discontinuation before the procedure.
and all the testimony is clear that before the procedure, the Plavix was still working. The Plavix is in the system for 5 to 6 days, still doing the job of preventing clotting. So nobody testified that from the 2 days before, there's any causation that caused the clotting issue to happen or the inflammation of the arteriosclerosis to happen.
So perhaps I'm missing something, but then isn't it his discontinuation of the aspirin that then is doing the heavy lift there?
I'm sorry,
Then isn't it his discontinuation of the aspirin that's doing the heavy lift there?
no, the aspirin's gone. From days 2 to 6, where ultimately the Plavix is out of the system, the only medication he's getting is Plavix, which is preventing.
Right, but had he been taking the aspirin the whole time, then the Plavix leaving his system may not have resulted in the occlusion.
That testimony is not there, and that goes to the Dahlberg issue. Dr. Miller's own test.
Set aside Ms. Dr. Miller.
Okay, well, nobody else testified. Dr. Loom agreed as well that it was the discontinuation of both. He can't say solely that it was the discontinuation of aspirin. I asked him, I ran through the line of
But
questions.
I don't understand why that helps you, if it's the discontinuation of both, right? Why can't the failure to continue to take aspirin then contribute to the
Because
situation?
That's the thing, you're trying to apply causation to an affirmative defense of contributory negligence, which does not exist, because the only issue that could be contributory negligence would be if he did something contrary to what Dr. Bolin advised him to do.
And Dr. Bolin advised him to start taking the aspirin again, right?
Dr. Bolin, without obtaining informed consent, which the jury found he did not obtain informed consent to do. So, but that then triggers, you're talking about afterwards, after the procedure, that then triggers Durfee saying, no, now we're at mitigation of damages, a different affirmative defense, not contributory negligence. So there is no claims, duty, breach, causation, damages for contributory negligence in this case.
Do you want to move on quickly to your JNOV argument?
I think we've briefed that pretty thoroughly, and I think every expert witness in this case has said that Plavix was a substantial contributor, the discontinuation to the clot formation. Nobody is arguing that, and nobody can say that the man who was taking taking this man off of the anticoagulation medicine did not cause the clot to form. Everyone agrees with that. They could have, and what should have been done is that the court could have said, you're right, causation is established. Now we can go to contributory negligence if the jury wants to. But that's after a finding of primary negligence. So they could have said, and what I think should have been done is say, we all agree, he's been found negligent. We all agree that Plavix played a substantial role in the formation of the clot, which led to the subsequent injuries.
But why couldn't the jury have reasonably said, okay, sure, he should not have just told him to keep off the Plavix, but you have not carried your burden of showing that it was that one thing as opposed to the discontinuation prior to the procedure, et cetera. And so therefore, even though there was negligence, you haven't carried your burden on causation.
Because I don't have to prove that it was that one thing. I have to prove that it was a cause. That's where the argument came up.
A proximate cause, which is what you agreed to in the verdict form. So, right? And that means something. It's not just any old cause in the causal chain. It's the proximate. It's a proximate cause, right? And So, I mean, why couldn't have other proximate causes be, more proximate causes have been the discontinuation of the aspirin, Mr. Hankins' poor health, the fact that the stents were are getting old, right?
Well-
I mean, there are other reasons that this could have happened. Bad things happen.
As Norfolk Southern says, it means something to us as lawyers and jurists. It causes, but what it means is antiquated. But you're right, there can be other proximate causes, but that's not the law. That's not what I have to prove. The burden that I have to prove is only that it was a proximate cause legally. The jury needs to determine that. They have to be advised of what proximate cause means in the jury instruction. Now,
I
similarly,
believe that you told the judge not to instruct them on what a proximate cause meant.
at that point in time, there was no, when the question came, because contributory negligence had been introduced, we had both the 5 series definition of causation, which was identified as proximate cause, and the 9 series, which are different. So it put us in an impossible position to advise the jury on something that we didn't know what they were asking. We didn't know if they were on question 2 or question 4 or question 8, wherever the approximate cause question was for contributory negligence on behalf of Mr. Hankins. So there's no way to know where he was there. And now the issue also goes to the causation for informed consent is much different. The causation issue is subsumed within the instruction. The defense counsel specifically requested it.
Nonetheless, you agreed, it would seem on the record, to the formulation of the question bifurcated, right? Which just takes the jury instruction and breaks it up into 2 parts.
I don't believe it does break it into 2 parts at all. Because this
Or
is
the jury could reasonably understand it to break it into 2 parts, right? They're instructed on the whole, on informed consent. And then they get the jury verdict form, which it seems you agreed to, and it has it in 2 parts.
It doesn't have it in 2 parts when you compare it to questions 1 and 2. For the malpractice claim, it says, do you find the doctor deviated from the standard of care? Do you find causation? That's the elements.
Right.
On informed consent, it says, do you find for informed consent? It doesn't say, do you find question 3?
Right, but colloquially, a jury could understand that to say, like, did you talk to him about this? And do you think that this is a proximate cause of his injury?
I think that flies in the face of the Blackwell case, where we have to assume that the jury looked at that question that says, do you find Dr. Boland failed to obtain informed consent? What does the informed consent jury instruction say? It says, in order to find for plaintiff, we have to find fail to advise the material risk, alternatives, benefits.
That would make sense if you didn't have question 4, right? Because if the entire instruction was contained in 3, then 4 would not be necessary. And so you're telling the jury that 4 is doing some operative work there, right?
And my position is that was not a jointly submitted verdict form. And I didn't get an opportunity to object to it because of the way it formed out. And when we look at this, that's why we look to the Weissman case and say, oh, hold on. The jury's back there deliberating. We still haven't given them a verdict form. The court has made rulings and the court's got to make a ruling on something. Here's what it is. Mr. Nace, your objections are preserved. There's very little that I can do in that position at that point, except ask if my objections are preserved.
Where did you, I know we're kind of getting back to where we started. Where did you object to question 4? Because I'm looking at, page 339, and it says the parties cannot agree on questions 7 and 8. I think the natural presumption is that they agreed on 1 through 6.
I just direct the court back to page 1330, where
Which
I
happened
object.
after you have submitted this form. So are you saying that you agreed to this form and then the next day when you go into court, you withdraw your consent?
I never agreed to this form. There is nothing in the record, even the emails that I don't believe should even be part of the record because they're not filed in the record, indicating that I agreed to the form. Not a single thing says I agreed to this. This was submitted by defense counsel.
Set aside the email that you contend should not be part of the record. There is a conversation between you, opposing counsel, and the court, where the court says, go talk, get back to me. there is an email that is sent to the court that is part of the record that says, here's what we have, right? And it's speaking in we language, right? And it attaches a verdict form that has a number of questions that have no annotations, and then a couple of questions that have competing proposals. And then from there, a verdict form is sent to the jury. How are we supposed to discern that you objected to that form on that record?
Going back to, well, I didn't get a chance, admittedly.
It would seem that your chance would be either in the email to the court saying, hey, and by the way, we really disagree with 2 and 4, or the next day when you show up and say, yeah, we sent the court this email, but opposing counsel misrepresented our position and we left out the fact that we really object to 2 and 4. There's no point at which it seems like you object to 2 and 4. And if you're pointing to me to your parts where you're saying we're preserving our objections, you never made this objection about 2 and 4.
I didn't make the objection about 2 and 4. The email was sent at 10:01 p.m. after another email that was sent to me, which had a different verdict form. And when we got to the court, initially right away, we started off with, let's get onto this. We'll deal with the verdict.
So it sounds like now you would like us to consider extra record information.
I think there's a whole host of conversations that were debated between myself and defense counsel.
I was trying to honor your interest in just looking at what went to the court. So I'm looking at what went to the court.
Right, and the counsel's trying to say that was a joint proposal, and I'm simply saying it wasn't a joint proposal.
When did you go into court the next day and say that? Where is that on 1330?
At page 1330, we come back in on September 8th. On September 8th, after that email had been sent on September 7th at 10 in the morning, at page 1330, I start talking about the repetitive nature of repeating this into prejudicial verdict form. Then we had to eventually get to the rest of the closing arguments. The court was, I don't want to say was pushing it because of COVID, but it was. We were in a difficult situation and we were trying to get the case submitted to the jury. And we decided we would debate the verdict form afterwards.
I'm sorry, but I'm looking at when you go back into court, and I don't mean to belabor this, but it seems like this trial took a lot of time and a lot of energy and a lot of thought by counsel. And to come now before this court and say you didn't get a chance just doesn't seem supported by the record. So I want to give you an opportunity to really tell me where you did, because if you look at 1323, right, the court says, I'd like to start with the email that I received. And then there is an extensive conversation between both counsel. And you're talking about various things. I believe you're talking about assumption of risk, right? But man, if opposing counsel had sent a verdict form that I didn't agree with, that would be the first thing that I would say. Judge, we had an agreement. We were talking last night, and then they hauled off and sent you an email purporting to be from the both of us that sent you a verdict form that I never agreed to and that doesn't have information that I would agree to. That is just not there, right? And so, counsel is speaking. Both counsel are speaking. That conversation doesn't happen.
So what happens right away is Ms. Kostowski goes to the jury instruction right away. And I'm responding to her in this conversation. It was a very short time period before we did, I think closings came right after this. This is, I think it's the second time I spoke during that afterwards, after Ms. Kostowski gives this argument where I address it's being a repetitive verdict form and prejudicial.
The court gives you the last word on 1335. And there's nothing about an objection to a verdict form that you didn't agree to.
And that's why I point back to 1330, and why I also go back to,
Right.
again, the Weissman case. I mean, it wasn't just me that the court had asked to
Right,
move on.
you go
from.
back to the verdict form in 1338, right? It's one of the issues. Our position is that the assumption of risk shouldn't be in there. Right? So you're talking about the issues that you care about, but I don't see any conversation about 2 and 4. But we've kept you up at the podium for quite some time, so I'm going to let you sit down.
Thank you, Your
And
Honor.
we'll hear from opposing counsel, and then we'll still give you several minutes on rebuttal.
Good morning, Your Honors. I think it's still good morning. My name is Jody Terranova, and along
Just
with
barely.
Robert Gibson, we represent the appellee defendants, Capital Digestive Care, and George Bolin, MD. And I would submit to you, Your Honor, that the jury verdict in this matter, as well as the lower court's ruling denying plaintiff's motion for judgment notwithstanding verdict, should be affirmed. I'd like to touch on a few points. One that is start with the failure to preserve the objection as to question 4 that you spoke about previously, and direct the court to the appendix at 1483 and 1485, which we referenced in our brief. And at that point in time, the jury had been sent back and the final verdict sheet was being discussed. And the trial court was reading and read into the record questions 1, questions 2, question 3, and question 4. And during that portion of the there is no objection there to question 2 or question 4 raised by counsel as to anything in the way that those questions were posed to the jury on the verdict form. And that was at the end, at the conclusion kind of this long timeline of putting together this verdict sheet. So just to close a loop on some of the arguments and points that Your Honor was making, it was a joint submission. There was no objection in email. There was no objection earlier on, but this closes the loop on those 4 questions. And then the discussion moves on to, or the only kind of discussion that plaintiff made at that time was as to, as I call it, the roadmap of where do you go if you check yes or no. And those were the only things that were disputed at that time. And then the conversation moved on to assumption of risk and never came back. So that's in addition to some of the points that Your Honor has raised during counsel's argument time, that was a point that we believe cements the issue that questioned the challenge to question 4 on the verdict sheet was not preserved in the underlying at the trial court.
So can we move on to contributory negligence?
Yes, Your Honor.
And do you want to explain to us why you think Ms. Hill is incorrect and that contributory negligence was properly submitted to the jury?
Yes, Your Honor. I think that there were multiple, there was testimony by multiple experts in this case. And the theory was not just that Mr. Henkin had failed to disclose his peripheral artery disease, his use of Plavix and aspirin in January, but there was testimony from defense expert Dr. Bloomfield that he stopped taking the aspirin and Plavix without speaking to his doctor. Mr. Hankins was asked after the procedure to wait in the procedure area or the post-procedure area to speak with Dr. Bolin, and he left. There was testimony as to that happening. And then finally, there was the instructions from the discharge that said that Mr. Hankins needed to restart his aspirin that day. And that did not happen. And there was plenty of testimony from not only defense experts, but even plaintiff's expert, Dr. Jim, that the failure to take the aspirin was a cause of the occlusion and ultimately his death. In addition, Dr. Jim agreed in the record, it said Appendix 779 and 780, that Mr. Hankin was negligent in failing to follow those instructions. And so the failures by Mr. Hankin at the time of the procedure is concurrent. It's happening at the same time. And that's why we do not believe that the Durfee case even applies to this matter. And in fact, they did allow for contributory negligence in Durfee. They just said that they couldn't argue contributory negligence for the plaintiff's failure to basically take care of his diabetes leading up to his issue with his foot, which is osteomyelitis. So there's a distinction to be made. And here, all of the alleged or the negligence against Mr. Hankin was supported by multiple experts and evidence. And a jury certainly could believe, had they gotten there, that Mr. Hankins was negligent, and his negligence was a proximate cause of his death.
So what do you think the jury was doing between question 3 and question 4, if not sort of perhaps importing contributory negligence?
Well, you can attribute a cause without it being negligent. For example, the failure to take his aspirin after, maybe they didn't, you put aside what Mr. Hankin did, but there was plenty of testimony from Dr. Lum, from plaintiff's expert, that aspirin was a cause of his death. And they knew that he wasn't taking it. And so their decision was, well, even if Dr. Bolin didn't explain the risks associated with it, we found, the jury clearly found that he didn't explain the risks, but then they decided it didn't matter because the aspirin was ultimately the cause. And so it didn't have to be, you don't have to have a negligent act in order for there to be a cause.
Or in order to defeat approximate.
Correct. Yes.
Okay.
And there was, again, plenty of testimony from both sides on that issue. In addition, it's the informed consent piece could have been that, as there was testimony, there wasn't any consent, or sorry, there was no explanation as to, the real issue is that he did not stop the Plavix and aspirin until 2 days before the procedure, which all the experts testified that typically you stop Plavix at least 5 to 7 days before. Really, the risk there was bleeding, and bleeding never happened here. We had the opposite. It was an occlusion. So clearly, if that was their thinking in finding against Dr. Bolin on informed consent, then it certainly would have been that is their reasoning as to why they did not find against Dr. Bolin on causation. And we have to take the jury's verdict. We have to take what they did and believe that they were following the instructions and use the evidence appropriately. That's the law of this court. We don't disrupt that. Turning to the issue of whether question 3 encompassed causation, I think as was discussed earlier, that was very clear to the jury. They saw that there was a causation question. I think when you look at civil pattern jury instruction 908 and compare that to 901, both of those instructions include the element of causation.
Do you think we need to reach that issue?
No, I do not, Your Honor. I think, Your Honor, it's really our position here that the issues as to the verdict sheet have were never preserved. And ultimately, on the issue of contributory negligence, the jury didn't even get to that question on the verdict sheet.
Well, do we know what the jury did? I guess is the question, right? Like, I mean, maybe they didn't, but maybe they did, right? So can we say that it's moot as you argue?
Well, in the sequential order, and you have to take the jury and following, we presume that they follow the instructions of the court and they 1, 2, 3, 4. There's no prejudice here. There was no prejudice to the plaintiff in this case. There was clear testimony from multiple experts that Mr. Henkin was negligent. And that his negligence was a approximate cause.
I mean, it's just hard to, right? If you go to the roadmap, right, they answer, yes, Dr. Bullen failed to adhere to the standard of care. And so if you answer yes, then go to 2. They answered no, that it was approximate cause. Then it says go to 3. If you find that Dr. Balin failed to obtain informed consent, they answered yes. Says if you answer yes to 3, go to 4, then you go to 4. They say that that was not approximate cause. Then it says if you answer yes, then go to 5. But they don't fill out anything else. Was there ever any objection to the fact that the jury didn't follow the roadmap? I mean, could someone have said, wait, they didn't finish answering the questions, so you need to send them back to finish filling out the form pursuant to the roadmap that we spent a really long time talking about?
No, there was no objection. There was no objection on that issue, nor was there an objection, as I think we discussed, on the issue of the use of the term proximate in the jury instruction. Or in the verdict sheet, I'm sorry.
Sorry, I may be misunderstanding my colleague. So question 4 says if you answer yes, proceed to number 5. If you answer no to questions 2 and 4, then sign the verdict.
Oh,
form and
sorry, I
print.
stopped reading. Yeah. Okay.
Okay, so they did properly stop at 4 once they
Yes,
answered.
yes,
no
I'm
on
sorry.
2 and- Okay.
Yes, they did. And so there was a proper, they did.
And
follow
so
that.
this was the roadmap that was agreed upon, though,
Yes,
to say if you answer no, then you don't have to get to the question of contributory negligence, which was 5 and 6.
correct. And this is a standard roadmap that we use in medical malpractice cases, and you don't reach the elements, you don't get to damages, and you return the verdict sheet. And that's why I say that, the issue as to contributory negligence is moot, because the jury never got to question 5 and question 6.
So I guess looking at this, I have sort of a second question, which is number 6 is about whether it was the proximate cause of his damages. So I guess I'm wondering, does that sort of suggest that this goes to, as your friend on the other side was saying, negligence we're presuming was after the fact and therefore goes to the measure of damages, or that it could wipe out liability entirely?
Question 6 would wipe out liability entirely because it is attached to question 5 based on reading the roadmap. Because even in contributory negligence, this court has ruled there also needs to be, a finding of a breach as well as whether there was cause.
Okay, so I think I'm still looking at the draft one and not the final one. So that makes sense. Thank you.
Yes, absolutely. And I believe there was, I think there was some discussion as to whether there needed to be a causation question associated with contributory negligence. That was worked out and eventually put into the final verdict form.
Do you have any arguments that you want to make on the JNOV question?
Your Honor, I think that it was absolutely appropriate for the court to deny the order, and I think we will stand on our briefs on that issue. I don't think I have anything else to add as to the judge's ruling at the time of order.
Thank you, counsel.
Thank you.
I'm gonna try to be. as
Mr.
quick-
Nace, we'll give you a few minutes.
Okay, I'll try to be as quick as I can. I just want to address the informed consent question that was raised by counsel on what Dr. Bowen testified, and to be clear, the evidence is at page 1271. Proper thing here, the question is, the proper thing here, the standard of care was to get a hold of him and tell him what's going on. You have a problem here with Plavix and the aspirin. Isn't that correct? That would have been the standard thing to do. I would have, as I said. I attempted to do that, but I wasn't able to because he left. I attempted to call him to do that. The damage, as I said earlier, had already been done. I had taken a large polyp location, etc. My point in raising that is that Dr. Boland's testimony on informed consent says that he would have, had he obtained informed consent, advised him on Plavix and aspirin.
Well, counsel, I wanted to ask you this question at the end of your argument, and your opposing counsel raised it. I want to raise a slightly different angle. Why couldn't the jury have just been looking at it and ignoring aspirin and just looking at Plavix, seeing that Mr. Hankins stopped taking both medicines without talking to his doctor? He left without waiting to talk to Dr. Boland. He left the instruction, do not call me. And then he ignored the instructions with regard to aspirin. And I admit I am more recent to this case than my colleagues, so maybe there's something easy in the record you can point me to, but why couldn't the jury have just found he ignored it? He just didn't, even if there was this failure to get informed consent, he would have ignored the instructions anyway. That's what he'd been doing, and that's what all this leaned towards. And so it just didn't matter.
Because there's no, I'm trying to grasp.
I know, I rather you have that. What's like, there's all these steps that say Mr. Hankins, stop Plavix without doctor instructions. Or maybe we don't know why he stopped the Plavix ahead of time, not afterwards. After the procedure, he didn't wait to talk to Dr. Boland, who would have talked to him about this. He left, he said, do not call me, in response to the discharge instructions. He then ignored those instructions with regard to aspirin. Why couldn't the jury have just been like, well, that's right, Dr. Boland didn't talk to him, he messed up there, but it wouldn't have mattered if he did talk to him, he wouldn't have taken Plavix anyway.
I think that would be inappropriate for anybody to do here, because we have to assume, as Blackwell tells us, Blackwell v. Das, that the jury actually followed the instructions, and we have not addressed this specifically. Counsel indicated that we're going off the basic pattern jury instructions. Counsel also raised the invitation of error in their briefing. Well, what actually happened in this case was defense counsel fought aggressively to include in the instructions for informed consent additional language. If you find that a reasonable person in the plaintiff's position would have refused the proposed treatment, then you must next determine whether the undisclosed risk caused harm of which the plaintiff complains. This is at page 1384. If you find the plaintiff has provided, I'm sorry, let me start again. If you find the plaintiff has provided that is more likely than not that a reasonable person in plaintiff's position would have refused the proposed treatment or selected a different option. You've given the adequate disclosure and the undisclosed risk caused the harm for which the plaintiff complains, then you must find for plaintiff. They looked at this instruction under Blackwell and answering that question of informed consent. This is what they were given. And they answered yes. They answered the causation question. They were then posed with question number 4.
The answer, no. The
They
question was bifurcated as you agreed to it, and they answered no as to approximate cost. That is just the record.
And this is where I say proximate cause, that question is a legal nullity. It is not required in the jury instruction for the jury to answer. They have already answered all questions required of them in answering question 3. And I think if ever there is a case in which Justice Ginsburg wrote, the term proximate cause is confounding to jurists, it is even more bewildering to juries. Nothing in today's opinion should encourage courts to use proximate cause or any term like it in jury instructions. Legal concepts such as proximate cause and foreseeability are best left to arguments between attorneys for consideration by judges and justices. They are not terms which are properly submitted to a lay jury, and when submitted can only serve to confuse jurors and distract them from deciding cases based on their merits.
And that's a concurrence, right? It's persuasive, it's not binding.
It is a concurrence, and it's what's been accepted by the underlying court here. And if ever there is a case where issues on jury instructions, the verdict form were argued over and over again, objections were made, counsels for both sides were told, let's move on from the objections, they're preserved. If there was an oversight on my part, thinking that I had made that objection when I raised it during the jury instructions, so be it. But this is why Weissman comes forward and says, when extenuating circumstances exist, this is where the court should look past the need for a strict adherence to an objection on every little thing that happens in a trial. This was clearly an issue that should not have gone back to the jury. And so with that, unless there's any more questions, I think that's.
Thank you, Mr. Nace. We appreciate your argument. Thank you, counsel. This case will be submitted and the court stands adjourned.
Thank you, Your Honor.